When Delia asked me to moderate a panel on the intersection of art, copyright, and artificial intelligence, I was really excited. This is a fascinating issue that I'm studying actively. But also at Berkeley Law, in the IP faculty, we have an embarrassment of riches, and I pointed out to Delia that Pam Samuelson, Molly Van Houweling, Jennifer Urban, Sonia Katyal would all be as good, if not better, moderators than I would be. And then Delia said, "Yeah, you were my fifth choice." so I'm going to try to live up to that. But I think making my job a lot easier are the panelists joining to me today. A quick run of show. Jed is going to give us a quick crash course on where we are at on the issue of copyrightability of AI-generated or AI-assisted images, and also how we got here. And then Kent is going to talk about his journey seeking registration for the work, A Single Piece of American Cheese. After that, we'll broaden the conversation a bit and ultimately, hopefully, include you in that conversation. So right now, I'm just going to hand it over to Judd to get us started.
Thanks, Eric. And if you don't mind, I'm going to stand up over here. All right, so as you all probably know, copyright is the area of intellectual property law that protects creative works of expression. So things like paintings, illustrations, sculpture, music, books, and movies. Copyright protection is automatic. It occurs at the moment that a work is fixed in a tangible medium of expression, that is, that when it's fixed in something that it can be perceived from, whether that's a notebook or a canvas or a computer hard drive. And copyright vests automatically in the author of the copyrighted work. But although author, that term, appears in the copyright clause of the Constitution, it appears many, many times throughout the statute that governs the applicability of copyright law in the United States, the Copyright Act, that term is not defined anywhere. And that kind of makes sense, right? Implicitly, when we're talking about the creation of things that are creative, we're usually thinking about people. But there are some exceptions to that. There are situations, you may have seen videos of elephants painting on a canvas. There was a famous case in the Ninth Circuit that involved a macaque taking a selfie of itself with somebody's camera and a claim of copyright over that image. There was a case that involved figuring out whether the macaque had standing to bring a copyright claim for infringement of that image, and ultimately the Ninth Circuit determined that it didn't. Courts and the Copyright Office have imputed into the Copyright Act what's called the human authorship requirement. So in short, for something to be protectable, the creativity behind it has to come from a person as opposed to an animal or a biological process or a machine. And with the emergence of generative AI, the boundaries between the human authorship requirement are being tested. So the first such case to test this boundary involved an inventor, Stephen Thaler, who created an AI named Darbus some years ago that he claims created this image on the left here called a recent entrance into paradise. And he claims that the AI, this was maybe 10 years ago now, created this image entirely on its own without any influence by him. And he went to the Copyright Office and he sought a registration for the image in the name of his artificial intelligence, Darbus. So he wasn't claiming copyright for himself, he was claiming it in the name of the AI, and the Copyright Office said, you can't do that, we have this human authorship requirement, AI doesn't count. Stephen Thaler subsequently appealed that decision to a district court. The district court upheld the decision. It was an easy call. He had claimed copyright in the AI, in the image for the AI. At the same time that this was happening, an artist, Chris Kostanova, had secured a copyright registration for a graphic novel, Zariah of the Dawn, the panels of which, and some examples you can see here on the left, had been created entirely with a generative AI tool, Midjourney. Kostanova had publicized on social media that they were the first to secure a registration that was for a work created with AI. And when the Copyright Office caught wind of this, they sent Kostanova a letter threatening to withdraw registration for the copyright if Kostanova didn't come back and identify what from the work was created with AI so that it could be disclaimed. Kostanova sought to defend the registration by pointing out all of the work that went into generating each of the images, all of the prompts that they had used to create all of those images, all of the versions of the images that were discarded. They had made some adjustments, some minor adjustments to some of the images, adding text, changing some of the facial features. The Copyright Office said that wasn't enough. Kostanova lacked sufficient control over what was coming out of the model for these individual panels to be considered its author. As to any particular images, Kostanova's efforts were, according to the Copyright Office, akin to commissioning an artist to create an illustration based on instructions. And it's black letter copyright law that when you go to an artist and you commission them to create a work for you, that the artist, not the person doing the commissioning, is the author of the work. So to get the rights in the work, when you do that, it has to be by contract, by copyright rights vest in the artist. Now, ultimately, the Copyright Office did recognize some protection for Zariah of the Dawn. The individual panels themselves were not copyrightable. They were treated effectively as if they were in the public domain. But the Copyright Office did recognize protection in the selection, coordination, and arrangement of those panels into a narrative, into a graphic novel. And so there was some protection that was recognized, but the individual panels were not. The next test case that the Copyright Office considered was Théâtre d'Opéra Spatial. This image actually won an award in an art competition. And the creator also used Midjourney to create it, and then another tool to increase the resolution of the resulting image. In their copyright application, the individual behind the work went to great lengths to demonstrate to the Copyright Office the various very detailed prompts that he had used in the many iterations of images that he had created before he arrived at the one that he wanted. Here, too, the Copyright Office said that this wasn't enough. Like the artist in Zariah, his contributions were akin to the suggestions to a commissioned artist, and he lacked sufficient control over the resulting outputs. In this other example, more recently, the Copyright Office rejected an application to register the image on the bottom here. The applicant had taken a photo of a sunset that he had made, and so he had copyright in that photograph. And he asked an AI model to restyle the photo in the style of Vincent van Gogh's Starry Night. Now, while the applicant may have had rights in the photograph that he took, the Copyright Office, consistent with these other decisions, determined that he lacked sufficient control over the specific way that the style was expressed in the overlay of the image. And so he was not able to copyright the stylized version of his image, even though he may have had copyright in the photograph itself. And then Chris Kostanova came back to test the waters once again with this image, Rose Enigma. They illustrated by hand the sketch on the left, and then claimed to carefully calibrate the image generation tool Stable Diffusion to control how the model modified the image so that it wasn't stochastic. So the way that these models work are they're probabilistic. When you put in a prompt, in general, you don't get the same image twice unless you're controlling for certain settings on the model. And the Zariah creator represented that they had controlled for this so that they could get this result that you see on the left. This application had been pending for quite a while, And then several months ago, a registration issued without comment. If you look at the registration record, which is quoted here, you can see that the Copyright Office did not buy their argument that they were entitled to protection for the version of the image on the left. They had to disclaim everything that was done by the AI model, so basically all that they were left with was the hand-drawn illustration on the right. And so that takes us to a single piece of American cheese, and I'll turn it over to Kent to describe his process.
Oh, great. Well, hey, everybody. I will give you some history before I talk about this work, because I think it kind of helps explain how I got here. Stable Diffusion is an open source AI model. It's a little bit different than something like Midjourney. Midjourney is hosted by a company. You don't really have access to it. You log into their application and you use it. But Stable Diffusion is different in the fact that you have the actual model file downloadable on your computer that you can actually alter and edit. And the size of these AI models is surprisingly small. I think most people, when asked, would say like a terabyte or a petabyte, maybe even bigger. It's actually 2.5 gigabytes or 5 gigabytes, somewhere around that. It fits on a thumb drive. And all of what people are creating with AI is coming out of that one file. I think that kind of shows the interesting, I would say, compression of concepts that happens inside of those models. It certainly isn't storing every picture it was trained on. It really is a very dense understanding of the English language. But I stumbled on Stable Diffusion and started playing around with it as a hobby, as a creator. And as every single one of these tools came out, all these capabilities that we could, play around with to understand how we can control the model and create what we wanted, I was building a tool alongside that. It started in open source. It was an open source project. It still is. You can download it and run it for free. We eventually became a company. And in 2023, I was putting a lot of YouTube content out, explaining and teaching people how to use these tools to create what they wanted. And I took one of the works that I had created and I submitted it to the Copyright Office because I was pretty confident that selection and arrangement would get that. And I got a rejection from the US Copyright Office, and that rejection letter stung so hard. And it really made me angry too. And it wasn't until, I want to say, I was watching a webinar that Cooley was putting on, because we work with them. And I saw Judd talk about all of what he just talked about before he showed you my work. And I said, this is the guy. I got to get in touch with him. I got to tell him we got to do this. And he agreed with me, because he actually had said, he'd proposed the same thing on that conversation. And that was kind of like, this guy gets it. He knows what I want to do. So we worked together to get a single piece of American cheese registered, and we succeeded. And it took a while, but we were able to do that. Now, the reason why is Invoke is not a basic text-to-image generator. It's a lot more complicated. You can probably view it more as an AI Photoshop, if you want to think of it that way. But all of the techniques that you saw in the previous examples, you can do all of those together in one place, but you can go back and you can riff with the AI. You can change parts and pieces. You can say, I want this here, I want that there, I want to change this. And that is what I did with this work. This work was in-painted, which is basically a selection a tool that allows you to regenerate parts of the image based on your settings. And you can add new things, you can edit and transform it. But I did that, I think it was 35 times is what we ended up counting it up to. And the process did not take like 1,000 days. It took me 10 minutes to make that image. And this was, and I'm not claiming that this is my magnum opus. I hope that this is not my magnum opus. What I was trying to do with this work is a little bit subversive, right? I was kind of, it's a little bit of a commentary because the process itself was kind of absurd, and so I wanted to make something that was absurd. But I wanted to find the minimal amount of human creativity that we could justify getting a copyright for. I wanted to find that line and prove that we can demonstrate that human creativity is involved in this process, because that's a starting point. That's the beginning point for us to be able to argue for a lot of what is possible with these tools and can really push the frontiers of this field and this new medium. I work with professionals, I work with creatives. One of my good friends is Bennett Miller, just finished with his show at the Gagosian. It's it's a new way of creating, and I particularly find it interesting, but I also find law interesting, so I'm ready for this panel because I think it's going to be a really interesting conversation.
Good. Well, the first question will be not too heavy on the law, but really about what you did here, because as you said, this was a work that you did in 10 minutes, and in many ways was kind of a proof of concept. You wanted to show that registration for this work was possible. What is to basically to locate the floor of human creativity that needed to be established to render an expressive work copyrightable that was created with AI with a model. So now we have the floor, and what do we gain by having that floor? What does this tell sort of follow-on creators that they can do now that they couldn't do before?
Well, I tend to view all of what is possible with these tools as kind of an additive component, in the sense that all of the techniques that you've seen in the previous examples, I think they've mostly been tested on their own in isolation. So Rose Enigma showed there's a technique called ControlNet, and that allows you to put in a sketch or a 3D image. It allows you to say the AI must color inside these lines, right? And what she was able to demonstrate is that you get a copyright on that initial input. You can kind of claim that, but you don't get it on the output. But what happens when you use that and then add 35 in-painting steps on top of it, where you do selection and arrangement plus that piece? Now you're starting to combine those together, and you're really starting to see that it is forming into a single work that you can claim a lot of authorship over. And I think that's really the frontier for us. You know, a lot of our clients were waiting for us to get this copyright. We work with a lot of people in media and entertainment, and I think there's a lot of concern right now around the protectability of outputs, especially when it comes to very important and valuable IP. And I think where we are now is we've at least settled the fact that it's not a whether we can get protection, it's what do we need to do and how do we need to design our process such that our artists and our creatives can get protection for the work. But the thing I like to emphasize, I gave a talk actually down the street at GDC earlier this year, and there was a lot of artists in the room. The thing that I love to call out is what this shows is that artists must be involved in the creation of IP. And so a lot of artists are maybe like initially upset by the fact that AI has gotten some form of copyright. But what I emphasized was it was not AI that got the copyright, it was me. And artists and creatives are important and integral to the process. And it's a very, I think, useful framing for a lot of people to understand that.
Just to unpack a little bit, we've been talking about selection, coordination, and arrangement, and that in the Zoraya of the Dawn work, Chris Casanova was able to achieve protection for the graphic novel, the selection, coordination, arrangement of panels. The type of protection that Invoke was able to achieve for a single piece of American cheese is similar. But behind this concept is the idea that there may be subject matter that is not susceptible to copyright protection. So facts and information are outside the scope of copyright. Simple shapes and colors are outside the scope of copyright. Images generated from ordinary text prompts or ordinary image prompts, according to Copyright Office guidance, are not susceptible to copyright protection. But if you take enough simple shapes and colors and combine them in interesting ways, you might get like a beautiful piece of art that is protectable. If you arrange unprotected information like you would find back in the day in a phone book in a way that embodies creativity, and there's a famous Supreme Court case on this, you might get some protection, might not be a lot, but you might get some protection in the specific way in which that information is arranged in a directory. And so the kind of protection that we're talking about here, I liken it in the case of a single piece of American cheese to a kind of collage. You could imagine, finding like an old shoebox full of photographs that are so old they're out of copyright and they're in the public domain, and then you arrange them into like a beautiful collage, right? The individual photos aren't protected, but the collage itself could be. And that was the type of protection that was accorded to Zoraya the Dawn. And it's the same for a single piece of American cheese. What makes a single piece of American cheese unique in this regard, though, is that it's a collage, but it's also a composite image, and it's like a seamless composite image. So you can't, it's sort of hard to separate out the discrete segments that were generated using AI from Kent's selection of where to inpaint those segments and how to modify them and which of the generations he chose from.
It's almost as if there was a thin plastic wrapper around a single piece of American cheese.
So I'm glad you used the word thin, because that's where I'm going with this. Is we often talk about copyright protection as it can be thick or thin, and what's so fascinating about this topic is oftentimes like new forms of new technologies and new types of work emerge that really raise fundamental questions about what should be subject to copyright protection. For example, software code. Software code is largely functional, and so we think that the functional things aren't entitled to copyright protection. But it's the particular expression of a piece of software can enjoy some copyright protection. So in this case, there's the copyright protection is for the selection and arrangement of the components of this image. But what does that actually entitle the holder of the copyright to? For example, if someone were to create an exact copy of this, that would seem to be a very clear case of infringement. But if people were to essentially decompile this image and use its components, would that be something that would be the subject of a potential claim?
So the question whether copyright protection for selection coordination or arrangement in an AI-assisted image is thin, I think it's going to depend on the particular image. I think it's going to depend on all of the work that went into it and how the image was ultimately created. If you're comparing like a Zoraya of the Dawn graphic novel to a traditional graphic novel that's created entirely by hand, well, you can't open up, a Batman graphic novel or Pick Your Poison, Watchmen, and pull a panel out and put it on a T-shirt and sell it. That's copyright infringement. But in the case of a Zoraya, the individual panels aren't protectable. People can use them, and so that is something that is fundamentally different for these types of works, for this type of protection, that is going to have implications for enforcement. Now, again, it's a little bit more complicated with a single piece of American cheese because it is a composite image. And so when you're conducting an evaluation of infringement, and when we evaluate infringement, what we're looking at is substantial similarity in protected expression. So the extent to which the allegedly infringing work is substantially similar in the protected elements with the work that is allegedly infringed. And so you've got to filter out all of the stuff that's not protectable, ideas, savoir-faire, common conventions, and the like. And in the case of works created with the assistance of AI, the stuff that is attributable to the AI as opposed to the creativity of the human author. And that's going to be a really interesting analysis when these types of issues are eventually battled out in court. But I think it's going to be a really fact-intensive inquiry, and it's going to depend on the work.
Yeah, and to that, and kind of I'm glad you brought this up about how these works must have, there must be the detectable presence of the human creator behind the work. That I think a lot of the concern around AI-generated images and the potential displacement of human artists by artificial intelligence has been about sort of trying to figure out whether or not AI should be conceived of as a tool to be used by artists or as a machine to replace them. And so is there a meaningful distinction to draw between AI-assisted works of art and AI-generated works of art? And do you see that line as something that's going to be moving over time?
Yeah, I mean, I think it's a really interesting question, particularly because we're building software that does this, so we think about it a lot. I think that there's going to be a lot, there's a term, if you're not familiar with it, it's become one of my favorite terms, slop, but it describes just like garbage that comes out of AI. It's just like not curated. It doesn't mean anything. It's just generated, and because it can be generated at volume, it is just it's like a garbage pit. And I think a lot of that is coming. I think we're already starting to see a lot of that. It's very low effort generations. And I think where my perspective is from a business point of view is that anyone who cares about the content they're producing is going to involve a human creative, because the human creative is almost necessary to get to anything that I would call worthwhile. You need that creative eye in order to take it where it becomes meaningful and where it becomes something that can resonate with other humans. I think that there are already systems in place that are going to start replacing stock images, for example, right? And you'll get an ad on Facebook that shows you a picture that was AI generated, and if you click the button, the algorithm will get a thumbs up, and it'll start generating more images like that for the next 100 or 50,000 people that are getting ads. I think for art, it really becomes a matter of creative intent. What are you trying to do? What are you using it for? Are you delegating a task to the AI, or are you trying to make something with it? And I think in that regard, if you are using the technology as a tool, you can produce art. And I think it really comes back down to what is the human's goal? What is that like ambition of theirs?
Great. And then, and for either of you, this question, I think this is very well put, but the difference between delegation versus using it as a tool. And the Copyright Office recently put out a report saying that, you know, there's going to helpfully clarify the boundaries of copyrightability of AI-generated images. And it came down pretty hard on the side of just, if simply entering prompts is not enough to establish you as a human author. And then for everything else, they said it'll be case by case, which is a really classic thing for the office to do, and it's not terribly helpful. It does make a single piece of American cheese like enormously presidential in a lot of ways, because there's not a lot of these precedents to go off in this space. But as the office is thinking about it, and as we're thinking about it, do you think this line between delegation and you know, utility of the tool is going to be something that we'll be able to determine in advance, or just going to come out case by case through a bunch of registration actions?
I'm going to let Judd answer first. I will say something, but I'll let him go first.
Yeah. I think certainly in the short term, it's going to be a lot of case by case basis. I think you're going to see folks testing the boundaries between protectable and not protectable, as Kent and Invoke did with a single piece of American cheese. And I think that's important. I think that these are markers that future artists can use to help guide them in trying to determine whether what they're doing is going to be recognized as protected by copyright or not. I think you know, over time that may change as we kind of create these bright lines through example, and as developers like Invoke continue to design tools that give creators additional control over artificial intelligence in a way that, you know, more clearly makes them the author of the end result.
Yeah, I think expression is really the word that I would use to describe it, right? Because I think it's like so critically important to call it expression for the purpose of copyright. But I think that I disagree with the U.S. Copyright Office on where they've drawn the line, and I think that's pretty clear. Part of that is because I think that there's a very, very deep misunderstanding of the technology. I think a lot of people treat the technology as a magic black box, and they don't know how it works inside that black box, but in our minds we concoct all sorts of stories, like small fairies taking all of the images that were in the training data and stitching them together into something new. And when you actually look at what is happening under the hood, there's a very weird mathematical relationship that is forming between language and visual content. And I think most importantly, that that relationship can be altered by the artist. An artist can train the model further. It's not fully baked and it's not kind of static as a tool. It can be dynamic. These models can learn from the artist. The way that I analogize this, the model is kind of like a dictionary, but the artist can add new words to that dictionary. And if you do that and then prompt for those words, you really are using that model as a tool. You're not relying on the predefined notion of a cat, right? You have injected your own meaning into the model. And I think that has not been explored yet. And I think it's incredibly important for artists to be able to have that access to the technology.
Great, and then that question of access also raises, I think, a tricky, both a legal point, but also an ethical point about and you mentioned that Invoke is open source, and people can look at it and understand how it works. And one issue that we're all wrestling in this space for AI use for everything in terms of benefits determinations, pretrial risk assessments, everything is a lot of the models are proprietary and they're completely opaque, and we don't know how they work. Sometimes we don't know the data that they're trained on. We just know the thing that went in and the thing that came out. And then some models are impressively open, where we know the data that they are trained on, as well as the weights and variables that the model is using. When it comes to the creation of art and the role of AI as a tool, is this something that artists should care about? Should they care about whether or not the model they're using is a proprietary black box or a glass box?
I think so. I think very much so, but I don't think the conversation is being had right now, because I think the conversation is just so, that's a conversation we have in like 5 or 10 years maybe. I'm like on the frontiers, so I see it and I see how incredibly important it is, but I don't think that the broader community of artists is at the point where they're asking, should we use an open source model or a closed source model? They're like maybe rallying against AI. And so we have to get there, but I think open is important because it allows the artist to modify the weights of the model and really turn it into an expression of themselves. The model, in a lot of ways, I'll share an anecdote. We worked with an artist early on in Invoke, very well-known artist, has done art for like Magic the Gathering. If you've ever played a nerdy card game like I have, it's got very, very beautiful paintings of like beasts and dragons and stuff like that. He's done that. He has his own artwork, but we trained a model on his art. And the interesting thing about his artwork, his project Angelarium, is that his angels are all these very lithe, surreal, androgynous creatures. But we went and labeled, this one's a man, this one's a woman, this one's a man, this one's a woman. When we got the resulting model, the definitions of man and woman had been kind of almost fused together. The model's perspective of reality had changed by training on his artwork. The definitions were foundationally different, and they mimicked his perspective. And I thought it was just like a fascinating emergent property of that exercise, but I think it shows that in some ways, the models can be made to reflect the perspective of the artist, and then they are a tool in a very unique new medium. And I think that only really happens to the degree that you really have like ownership of that when it's open source. There's a lot of tools online that will let you train the model, but then they're going to charge you a monthly fee to keep coming back and use that model, right? It's like, it's not really your model, it's their model. You've just kind of rented it. And I think having access is incredibly important for an artist.
Yeah, that's an interesting point. So as like a bulwark against concerns around not having control over what's coming out of these models, actually exercising control over the model itself to train it so that it reflects the perspective of the artist.
It's the next one. It's
Yeah,
the next
that's
one,
interesting.
right? It's the next one.
So you mentioned some of these models you have to pay to use. A lot of them you have to pay to use, and I think that's something that, like, totally understandably, artists are incredibly incensed about. Is that a lot of these models were trained off of their works. If they were available from publicly addressable endpoints of the internet, then those were the works that were used to generate the model that is now generating works that potentially could compete with or displace their own works. There right now in the United States is just this raft of litigation over the question of copyright as it relates to the inputs of these models. Ed Lee is doing an immense public service by maintaining a website called ChatGPT is Eating the World that has, among other things, a map of all current US litigation. And I looked this morning and there were 30 cases currently pending in district or federal district or circuit court over different questions of copyright as it relates to AI. And so maybe for Judd, but either of you really, do we think that this is going to be a situation where we just are going to be getting clarity, like case by case, and that's going to be influencing the way that these tools are both developed or used, or do we think that eventually there's just going to be some sort of global licensing solution to this entire question?
So is there going to be a global licensing solution? I think, look, these cases in general are being litigated over the issue of whether the use of copyrighted content without permission to train generative AI models is a fair use or infringement. And so there's litigation right now that's active against all of the major generative AI developers, both the large language model developers like OpenAI with ChatGPT and Google, and also a number of developers of image generation tools. There's some litigation against developers of music generation tools. I don't see how a licensing regime would develop if it's ultimately fair use, right? I mean, that is the very issue that is being litigated right now. I am also highly skeptical that a licensing regime even could develop in the event that courts ultimately find that the use of copyrighted material to train these models is not a fair use. I mean, that is also one of the issues that's being litigated, whether there is a sort of infeasibility to licensing in these contexts, because the volume of data that's necessary to train these models is so large. I mean, it's the numbers that we're talking about when we think about like the image models, it's billions of images. When we talk about the large language models, it's text corpuses containing trillions of words. Numbers that are so large they're effectively meaningless to us because we have a hard time comprehending beyond a few thousand. There's sort of a practical infeasibility to being able to license that volume of content, and then how do you even value it? How do you value an individual work when it's such an infinitesimally small component to the corpus? You can add or subtract any particular work, and it's not going to perceptibly affect the performance of the model. I mean, I think about like beaches are great. We all love beaches. Beaches have immense value, but like, how do you value a grain of sand on a beach? I think we are going to get clarity from the courts. Some preliminary clarity from the courts, a couple courts, potentially very soon. And then, we'll see where things go from there. But I think the licensing as an answer, one, I think it's putting the cart before the horse, because if it's fair use, a licensing market, nobody's going to, it's not going to be feasible.
I mean, I've got opinions, but I think he said a lot of what I think is probably true. The only thing that I'll add is I don't know. I think there's an immediate reaction to an artist who feels like their work has been exploited and that they have not been compensated. I think that's like reasonable. I think the broader concern of most artists that I've talked with is not really any individual model. It is the broader technology, right? It is the capabilities that we have unlocked as a society. And I don't think that having a licensing regime would be beneficial to individual artists first, but secondarily, I don't think that the licensing compensation would really be that much. I think, for an example, Adobe released a Firefly. Their model's called Firefly, and they I won't call it a bait and switch. They had a stock image library, and they had paid all of the stock image creators for this large library called Adobe Stock. And they took all of the assets in that and trained a model on those assets that they had kind of already had license to. And they did distribute compensation to the individual holders of those images, and made the exception of their normal rule, which was payouts of $25. They made an exception because some of those payouts were as little as $1 for the images that they licensed. So it's not like, and that was a one-time payment. It's not like royalties or things like that. It's like a one-time payment of $1. I don't think that the artists benefit from that, and I think what they benefit more from is fair use, because then you get open source models. In a world where there's a licensing regime, you have almost no open models, maybe at all, right? Because there's no way to fund an open model that is accessible to everybody when nobody's going to pay for it.
Yeah, and I will just note that most of the licensing agreements that have been reached relative to training large language models so far have been with like Getty Images or large sort of copyright holders, and it is unclear how much of that I'm not sure how much revenue there is in those deals, or how much is actually getting to individual photographers or individual creators. But there is something, and I think even if you, as I do, believe that a lot of the training is fair use, that there are some cases, and the one in particular that has struck me recently was the Studio Ghibli AI generator that basically allows you to take like any image, upload it into a model that will output an image that looks like it was hand drawn by Hayao Miyazaki, the beloved animator of my daughter's favorite movie.
I may or may not have created a few of those.
Yeah. But there it's not. The model is not reproducing a work. And again, copyright vests in works. They do not vest in feels or
Style's not protectable.
Yes.
Right. Style's like an idea, and ideas aren't protectable.
Yeah.
What's protected is the way that ideas are expressed.
Right. But do you see that? Do you see either on the protection for, like sui generis protection for styles, or something like a moral rights? You shouldn't be allowed to do this if the creator objects to it. Do you see tools like Studio Ghibli AI like injecting new life in some of those efforts and some of those debates?
You know, I'm just like an armchair observer of this, like everybody else. So I don't have any, particularly unique insight other than somebody who's kind of watching the industry and the commentariat on this stuff. But I don't know. I don't see us having a movement to protect styles of art in the United States. I don't think that would be a good thing. I don't think that would be a good thing for artists. I think, art very much is often a dialogue with other art. In particular, you look at the art in an institution like MoMA, or other visual arts, painting in particular. Any good painting exhibit is going to have works from a variety of different artists that are part of a movement, all kind of communicating with one another through variations of the same style. I think that's how art evolves. That's what the history of art throughout the world has been. So I think that would probably be counterproductive to the arts to have something like that. And I don't know that there's really a taste for it. And then on the moral rights thing, we haven't recognized moral rights in the United States, notwithstanding that there are these rights that are recognized in some other countries, in particular in Europe, that give artists sort of additional control over how their works are used, even after they've put them into the world, even potentially after sometimes they've sold a work of art to somebody else. They might have the right to protect it from being like destroyed or deformed in some way. And again, I don't know that we really have a taste for that in the United States. I'm skeptical of that just because we have such strong views on like free expression and the like that I think run counter to the recognition of those types of rights here. But maybe that changes over time.
I generally agree, so I won't say much more than that. The one thing that I'll say is I think Studio Ghibli AI as a label of your generator will likely get you sued, but not for copyright infringement, right?
That's a trademark infringement.
Judd's also a trademark lawyer. So I want to open up this one to questions from the audience, but I want to ask just very quickly, both of you, just to give us a quick view into where we are like 5 years from now. Do we have something like repose over the question of whether or not this type of use of images is fair use? And also, do we think we're going to be in a world where we've accepted AI-assisted art in competitions and exhibits alongside works that are entirely the craft of human hands?
Yeah, so on the fair use question, I think we will have clarity in 5 years on that question. And on the issue of, are we going to see AI-assisted works side by side with other types of art? I don't see why not. I think AI is just a tool, like other technologies that have become commonplace tools for artists, like cameras, right? I think people are going to create important, meaningful art that involves artificial intelligence. I don't know, when or what or who's going to make that, but I think that that's just inevitable that that's going to be the case, and we've already seen that a little bit. There was some controversy around this, but the movie The Brutalist that came out last year, artificial intelligence was used, I guess, to modify Adrian Brody's Hungarian accent in certain scenes to make it more authentic. AI was also used by, I believe, the set designer to help him ideate on some of the architectural designs that made their way into the movie. And I think that's great. I think that put tools in the toolbox for this low budget film to help make something that I thought was really great.
Agree on fair use. I am maybe less optimistic about the time frame of people accepting AI art. I think it's, I hope, and I'm working to try to make that happen within 5 years, but I think that we're just at a weird, strange time in society right now, broadly speaking. And I think this is a topic that is bigger than just like art, right? It's AI. AI as a technology, I think, has a broader societal implication, and the conversation is bigger than art. I think that makes it more likely that we might have people who are holdouts on the AI topic, but I'm optimistic that eventually we'll get there.
Yeah, if AI replaces all of our jobs in the next 5 years, there might be some pushback.
Well, we'll see. Okay, at this point, I would love to open the floor. I will be, for the historical record, I will be repeating your questions, but please raise your hands.
Hi, I'm Sheila. Sorry, I joined late. I'm also not an attorney, so expect me to ask a very dumb question. This picture that you created, right? I assume the base was somebody's face, somebody's image, right? And then from there on, AI most likely applied a few things. Could have happened, right? Maybe let me finish my question. So it could be that it could be a very famous person, and your final rendition could actually look like that famous person. So does that famous person then have copyright to this?
So I'll explain how I did it, and then I'll let Judd answer that question. This was generated purely from AI. There was no base face. So it was an AI-generated image. I typed a text prompt, and then I edited from there. So there was no base face. I think the prompt was something along the lines of a fractured woman's face made of stained glass. Or there's a prompt that I put in. But the face was generated by AI, and AI is notoriously good for generating faces of people that don't exist. This has actually been like an area of research for the past 5 to 10 years. You certainly can create images of people that do exist, And the question is, do we know whether this is or is not the face of someone real? I would argue that it's unlikely that someone looks like that, based on the current my current interpretation of this image. But I'll let Judd talk about like if I were to generate an image of someone's face.
Yeah, and so look, the way that these models are designed, they are developed to create new things. So it's highly statistically unlikely that this looks like any real person in particular, given the stylization. In the sort of very unlikely event that somehow turned out to be the case, well, first of all, people don't own copyright in their likeness. There might be publicity rights that an individual could own in their likeness, and so in theory, there could be a potential right of publicity issue. Like if you generate an image of Michael Jordan, for example, unwittingly somehow, and then you go market a product using that image, you sell luggage with your AI-generated image of Michael Jordan, there could very well be a right of publicity issue. As far as copyright is concerned, even if there were potential copyright infringement, it is well settled that a copyright owner does not actually own an infringing work. So in that scenario, the work that's created, it might be infringing of copyright, but is not something that the infringed party would then own in turn.
And just to answer or go back to the point, because I don't want to dismiss it out of hand, you can generate pictures of people that do exist using this technology, right? Like that is very possible. People do it.
It's fun.
Sure, yeah, exactly. If you use OpenAI's newest model, it is extremely good at it, and anyone who's a celebrity is definitely in that model. So that is something that's possible. I think it's unlikely in this specific case, and like Judd said, I think other issues would be more relevant.
Hi, so I'm a visual artist, and I have a question for both of you. I'm curious about your outlook on the technology and then the potential sort of copyright and legal implications of cross-mode creation. So if I was to use a music generator, but give it, say, a drawing of that I've created and say, create a musical piece based on this, and then, so that kind of outlook, both in the technology, but also then in the legal aspect in terms of is that enough human touch, or because it's crossed modalities that becomes more complicated?
From a technology perspective, you can definitely do that. So there are multimodal models, and what that means is they understand different modes of communication. The image generator that I referenced earlier today, the OpenAI's 4.0 or GPT Image 1 model, you can actually provide it a picture of something, and it will understand that and help you generate images based on that. You can say, look at the style of this, or look at the color of the hair, and I want someone with that same color. Like, it actually has you can have a conversation with it and use it in that way. So I think it's very, very possible and plausible that you could put an image in and have music come out. Now, whether it would be good or not, I don't know, but I think it's very plausible that you could do it. I certainly probably know the answer that you're going to say, but I'm going to let you say it.
And you might disagree with my answer. So from a copyright protection perspective, I think it's pretty clear that the Copyright Office would conclude that that's not protectable. It's sort of like the example that I showed of the photograph of the sunset that was then put into Stable Diffusion and overlaid with the style of Vincent van Gogh's Starry Night. It's a different medium, right? You're taking an image and asking a music generator to create a song in the style of the image, but it's the same principle. And so I think the Copyright Office would reach the same result. Now, look, the Copyright Office, their opinions have a deferential value and are relevant to whether or not creators can get a copyright registration, but they are not the final word. And so some of these cases, like Théâtre d'Opéra Spécial, which is on appeal, could could conceivably come out different ways in federal courts. And, I imagine eventually we'll have some Supreme Court precedent on the boundary between protectable and unprotectable in the context of AI-assisted content. But we're not there yet.
What I would do in your case, though, is if you were to do that, edit the song, make it part of a composition, right? Don't just wait for something to come out and take that. Take it into a DAW and edit the music and create something new, using that as part of the toolkit, but not as the totality of your expression.
Yeah, the more human touch, the more human touch points in a given work that's created with the assistance of AI, the more likely it's going to receive some level of protectability.
Hi, I'm a graduate of Berkeley Law from years ago. I have a question, both for first two-part question. First, I'm just curious why this piece is called Single Piece of American Cheese. Where is the cheese? But
It is a melting piece of cheese, but if you look on top of this woman's head, there's it's a very, very like orangish, processed food looking piece of American cheese that is now melting down the side of her head.
that's what I thought. Thank you. So I do have a legal question for the lawyers here. So these days, I know a lot of small businesses use AI, ChatGPT generators to generate both names and, of course, the brand, the images for the companies. But of course, that per se would not be copyright protected because it's purely generated by Gen AI. So I'm just curious, once the image becomes really associated with the company, with the brand, and if somebody starts using the company's image, like Apple, right? The image of
Are
Apple.
you talking about like a logo for the
Yeah,
company?
logo.
Yeah,
Logo,
okay.
yeah. So what do you think the courts would decide in that instance if the company sues for copyright infringement?
So I've got good news. If you're using generative AI to create a logo for a company, assuming that it's not otherwise infringing some other business's logo, that is protectable probably under trademark law, even if it's not protectable under copyright. And frankly, a lot of logos are too simple in their design to be protectable by copyright anyway, and Copyright Office decisions are littered with the bodies of logos that the Copyright Office has rejected protection for, even without this human authorship issue. So trademark rights are created through use of symbols in commerce to designate the source of goods or services. It has nothing to do with this human authorship issue. And so a symbol can really be anything. It can be words, it can be a design, it can be, in some instances, a color. And so long as the AI-created logo is being used in the correct way as a source identifier, there's no reason why a business wouldn't be able to accrue rights in it.
Great. I've been given the 1 minute warning, so we have time for one more question. Go ahead.
There you go. Can you hear me? Great. Dan Lappin with Intelligenesis Designs. So I do work in anatomy and physiology and how our models of anatomy and physiology inform our concepts of medicine, law, and economics. We all arise from biology. So about 50 years ago, there was an author named John Nesbitt that some people might remember, and he had a concept called high-tech, high-touch. And this is that when laptops were just like, oh my gosh, there's this portable computer happening. So the flip side question is, as we've been thinking about how technology is informing what it means to be human on the planet, what's the next iteration of our conversation of how AI is challenging our concepts? What does it mean to be human on the planet? What is work? How do people survive? People getting displaced by AI. What's the kind of the flip side philosophical question of what does this AI mean and where we're going? Not just art, but the whole concept of expression, human biology, and the concept of work.
Simple question, really. I'll give you where I'm at. I don't know that I've got an answer to the question, but I can say like this is where I'm at, right? I think about this a lot. I think about how quickly the technology is moving. I mean, I'm in the space, sitting at the frontiers, and there are moments where I come out of my office and tell my wife, oh my God, it's moving so fast, right? Because something has just come out that's really blown my mind. I think we're going to have to change, broadly speaking, as a society. I think we're going to have to change a lot. I think that's true. Take AI aside, I think that's still true. I think AI is just another thing that requires us to change, but I think it is going to be a catalyst for great change. I do think that it will fundamentally alter our perception of what it is to be human. I think that we will better understand ourselves, I think more as a process, as becoming, as growing and changing in perpetuity. And I think a lot of people see themselves as like static identities today, and I think that will change because of AI. But I don't know how to solve all the problems that that's going to cause. I think it's going to cause a lot of problems, but I generally feel like it's coming. I mean, I don't know, that's kind of ominous.
Yeah, I know. It's like, at the pendulum of if you've got crisis, where's the opportunity? And the concept is, what is generative biology? You've got these cultural institutions and the desecration under war times of these cultural artifacts. How do these artifacts help us come alive?
Yeah.
What does it mean to come alive? Like if you look back to the Great Depression of 1929 and the devastation that happened in society, how do we come alive and how arts help us come alive? So those are some of the inquiry questions.
I think we would have some great conversations at cocktail.
Let's do it.
Great. And to move us there, please join me in thanking our panelists.